Priya was thrilled about attending a prestigious business conference in the US. But during her visa interview, she submitted a fake employment letter, thinking her part-time job would not be enough. The consular officer caught the fraud and her visa was refused under section 212A6C1. Determined to set things right, Priya sought legal help, applied for a waiver, and provided evidence of her genuine intentions. Her waiver was approved and she got a second chance to achieve her dreams. If you or someone you know has faced a similar situation, do not worry. Let's break down what this refusal means and how to handle it. A refusal under section 212A6C1 means that the consular officer determined an attempt was made to get a visa or enter the United States by willfully misrepresenting a material fact or committing fraud. This could include providing false information, submitting fake documents, or hiding important details during the application or interview process. Now, let's break this down a little further. What do we mean by misrepresentation of a material fact? Misrepresentation means being untruthful about something important in your application. A fact is considered material if knowing the truth would have made the applicant ineligible for a visa or entry to the US. Unfortunately, a 212A6C1 refusal is a serious matter. This ineligibility is permanent, which means it applies every time a visa application is submitted in the future. But don't lose hope just yet. There may still be options available. The consular officer will let the applicants know if they are eligible to apply for a waiver of this ineligibility. A waiver is essentially permission to enter the US despite the refusal. Eligibility for a waiver depends on individual circumstances, including the type of visa being applied for and other factors. Here's what we recommend if someone has been refused under section 212A6C1. Understand the reason for the refusal. Carefully review the explanation provided by the consular officer or in the referral letter. It is important to understand what led to the determination of misrepresentation or fraud. Explore waiver options. If the consular officer advises that a waiver may be an option, look into this right away. Waiver applications involve submitting evidence to demonstrate that entering the US would not harm the country's interests and that a second chance is deserved. Be honest in future applications. Honesty is critical moving forward. Any new misrepresentation will only complicate matters further. Now seek legal advice if necessary. Given the complexity of 212A6C1 cases, consulting an immigration attorney may be a wise choice. They can guide applicants through the process and help strengthen waiver applications if applicable. To sum up, a refusal under section 212A6C1 is a serious permanent ineligibility, but there are pathways to address it, such as applying for a waiver. Take the time to understand the process, gather any required documents, and seek help if needed. Thank you for taking the time to learn about section 212A6C1 visa refusals, and remember, with the right guidance and preparations, you can ace your immigration. Good luck.